Hi there, and welcome to the masterclass. Today I'll be sharing over 30 years of advising small business owners, employers, stripped down to one simple legal system designed to eliminate your employee wage and hour lawsuit risk. But before we continue, I'm a lawyer, so I have to give you a disclaimer. So all of the content of today's masterclass is for informational purposes only, okay? Do not implement any of what you learn here without the advice and counsel of an experienced and knowledgeable employment and labor law attorney. Okay, enough of that. Okay, so we'll do a little bit of a role play here, if you don't mind, okay? Now picture this. Now this is you. It's Tuesday morning and you're sitting at your desk. You're called to reception and you're greeted there by a stranger who hands you a stack of papers, okay? It turns out it's a process server. And so as you flip through this stuff, your heart and your breath drop to the bottom of your stomach. You can't breathe. You know, it turns out you're realizing that one of your best employees has just served you with a multi-million-dollar class action lawsuit. Rest periods, meal periods, itemized wage statements, things you didn't even realize were problems. And now you're staring down the barrel of hundreds of thousands, if not millions, of potential liability exposure. Now, I've seen countless potential clients sitting where you're at, time and time again, great people, treat employees well, work their asses off, and still, they got blindsided by a lawsuit they never even saw coming. Now, and it kills me. It's been killing me for 30 years. I've been trying to, get all of you small business owners to pay attention so that you eliminate these lawsuits in the first place. But, if you ever had that pin in your stomach, wondering whether you're one disgruntled employee away from a lawsuit that could absolutely tank your business, then today's for you. I'm going to be showing you exactly how to avoid that. But first, let's make sure this is actually for you. So who is this for? This is for you if you've ever felt like California law protects your employees, but not you. And if you've ever been told, quote, just treat people right and you'll be fine, end quote, and this is also for you. Finally, this is for you if you're done reacting to problems after they explode and you want to get ahead of problem employees once and for all. Sound like you? All right, well, great. Stick with me. But if you think that lawsuits only happen to bad people, then this is likely not for you, although you're welcome to stay. And by the way, you're badly mistaken, as you see with one of the stories coming up. And if you actually enjoy litigation, and enjoy spending time with your fabulous litigation team, then this likewise is not for you. Excuse me. Who here actually likes litigation? Even lawyers don't like it, believe it or not. So here's what we're going to cover in the next 25 minutes. By the end of the session, you'll know how smart business owners reduce their liability exposure from wide open to as close to zero as possible while keeping their hard-earned money. Now, this isn't theory. This is a battle-tested legal system that I've developed over 30 years of advising clients go from millions of exposure to stopping cases dead in their tracks, and in 1/5 the time. You'll walk away knowing exactly what's leaving you exposed right now and what to do about it. And whether you work with me or not, you'll at least walk away with a clear roadmap on how to prevent years of misery and millions of losses. And here's how we're going to get there. We're going to discuss why the best intentions that everyone talks about is only setting you up for a multi-million-dollar disaster. Second, we'll talk about the fork in the road that most small business owners miss and why it determines whether they pay $20,000 or $2 million when the lawsuit hits. And third, we'll talk about what the 1% are doing before they ever need a lawyer and how you can do the same. But first, a quick intro so you don't think I'm just making this up. I'm Scott Shibayama, founder of Vision Law Corporation. At Vision Law, we protect California employers against employee lawsuits. We've helped over 300 businesses in the past 24 years, from restaurants to bakeries to service providers, reduce their liability exposure by over 300 million combined. But I've sat in rooms, in mediations with clients, you'll see the story coming up, facing down the barrel $15 million of PAGA class action exposure. Okay, now I've walked them from the ledge, saved them tens of millions of dollars, and resolve their cases quickly. But I've seen way too many, really good people lose sleep. I hear this every time. Lose sleep, lose money, and unfortunately, the ultimate loss, even lose their businesses because they didn't know what they didn't know. But this isn't about me. This is about getting you a real legal playbook so you don't get burned. Now, time for a quick poll. Who here has had or has a problem employee? You have a situation right now. You've had one in the past. You haven't yet. But that's the point of today's masterclass. If you pay attention, we can keep it that way, right? Don't get sued in the first place. Okay, so let's get back to the question at hand. Why is it that California employers keep getting burned by this wage and hour stuff anyways? Okay, well, I think it has to do with what you probably think you're supposed to be doing or what you've been told to do, right? Because here's the thing, it's not bad advice, it's just incomplete advice. And incomplete leaves you wide open. So up on your screen, there's a couple of, quote, best practices, or if you want to call them unintended practices. Okay, first, just pay people fairly and treat them well. Okay, what do you hope you do? Keep your employees happy, right? Avoid lawsuits, build loyalty. But what it actually does, it leaves you completely defenseless when one of those employees, and they always bite the hand that feeds them, one of those employees you treated so well decides to sue you anyway. Because here's the thing, California law does not care whether the employees like you. Like I tell all my business clients, once you've been sued, you've already lost. And that one gap, that's what turns a $15.50 an hour employee into a $1.6 million class action. Okay, second unintended practice, pay for a lawyer only when you need one. What you thought you'd do, right? Save a ton of money on the front end by hiring a lawyer only if and when you have a problem, which you're never going to have, right? Okay, what it actually does, it turns a small problem, the $5,000 problem, into a $360,000 problem. Because once you have to call that lawyer, guess what? You've already been sued. And like I said, you've already lost. Now you get to play defense with no leverage. And you get to pay your lawyers hundreds of thousands of dollars. Now, who wants to do that? Pay lawyers, hundreds of thousands of dollars just to fight it. And know this, because it's a wage and hour case, you have the privilege of paying for the other side's attorney's fees and costs should you lose. And you still have the settlement or the judgment to contend with. So let me show you what this looks like when it all comes crashing down. Okay, you're up on your screen, you're looking at a rather somber picture of a bar. Oh, and by the way, I'm going to be telling two stories that are based on cases that Vision Law, my firm, has handled. Okay, names changed to protect the innocent. So for this one, we'll call it Lori's Place, right? Nightmare story. Lori, 20 plus years in business, single shareholder S corporation, owned and operated a couple of bars that happened to serve food. Now, very loyal clientele, great reputation in the community, and reasonably profitable. At any given time, Lori's Place employed about 20 regular employees, okay? 85 over a 4-year period. Now, one of these employees worked for Lori part-time, 4 days a week, 6 hours a day. So it's just 24 hours a week for about 2 years, paid, guess what? $15.50 an hour. Now, Lori had treated this employee very well, never had any problems. They had great conversations, and Lori even considered this person to be a friend. Until one day, this employee served Lori personally, so she had personal assets at stake, and her S corporation with a class action lawsuit. Now, that's the actual copy of the complaint up on your screen that's been redacted. So the numbered items 1 through 8 are claims that are very typical of any wage and hour case. Failure to pay minimum wage and overtime based on what? Working off the clock, typically. Failure to provide rest periods and meal periods. Itemized wage statement violations and waiting time penalties. So when Lori got this, she's shocked, pissed, and heartbroken all at the same time. Why? Because she wouldn't have fathomed that this employee she treated so well and who she considered to be a friend would do this to her. And furthermore, she couldn't believe that she could possibly even lose. She swore to me over and over again, Scott, I pay this person all their wages and they got all their breaks. I can prove it. We should win. I said, okay, great, Lori, show me your written policies on timekeeping, rest periods, meal periods, and overtime. Lori didn't have that. So I said, okay, Lori, show me your daily time records for your employees. Lori didn't have that either. Lori did not have her employees keep track of their time. She paid them based on the schedule. Okay, probably most of you here know those are big no-nos for our defense of your case, should you ever get sued. Okay, and so when I sat down, and so I told Lori, when I sat down with Lori, because of that, we calculate the exposure was not good. So $7,000 in rest period penalties, another $7,000 in meal period penalties, $2,550 in itemized wage statement violations of all things, and then $2,800 in waiting time penalties. What's that for? So if you add that all up, it's like $19,000 for the one employee. Okay, so I'm sure if you had to pay that, that would hurt a little bit, but I'm also quite sure it's not going to break any of your banks or put any of you out of business. But don't forget, this is a class action. And because of that, one employee can drag all of their unwilling coworkers into the case without their consent. Okay, so suddenly Lori's not looking at just 19,000. She's looking at 19,000 times 85 or 1.6 million. So now Lori is, blown away. I mean, it was as though she'd hearing this for the first time. So I can't believe that, California employers don't know about this wage and hour stuff. Okay. And she told me, shooting a messenger. She asked me at one point, right? Why is it that California employers only care about employees? What about us small business owners? And then she cried, quite literally. I could hear it, that it wasn't fair and it wasn't right. And I told Lori, like I tell everyone in her shoes, I get it. I call it legalized extortion. And it's not fair. It's not right. But it is crazy California law. And so I advised Lori that, look, hey, we need to try and settle this thing on a one-on-one basis only and just hope that they dismiss the class allegations. Lori's a smaller employer, so on the smaller side. So I picked up the phone. I called opposing counsel. Their opening demand, $80,000. So that's 4x what I calculate to be the high watermark in damages. So I went to Lori. I said, look, they want $80,000, because of the risk. And Lori's like, what risk? I told you she got paid all of her wages and got all her breaks. We should win. I said, Lori, no, trust me. Actually, you have risk. Okay. And that risk could cost you up to $1.6 million. Okay. So you should be prepared, Lori, to pay up to $20,000 to settle this thing and hopefully make the whole thing go away. Lori's furious and she's just super frustrated, right? I get it. She can't believe or understand why she should have to pay this employee who she knew in her mind got paid all their wages and who got all their breaks a penny, let alone $20,000. And so, Lori didn't want to pay this person anything, right? She didn't want to settle. And I get it. But here's what I had to explain to Lori, right? Okay, well, if you don't settle, unfortunately, you have to fight it. And that means paying my law firm a lot of money. And litigation is very time consuming and super expensive. Then I walked Lori quickly through the litigation process. It's up there on the screen, steps 1 through 5. I won't bore you with the gory details, but suffice to say that if you add up all the time involved and the money you pay your lawyers, it's ridiculous. 4.5 years of your life fighting the lawsuit, $360,000 of attorney's fees of your hard-earned money to pay lawyers. It's not something you want to do, obviously, right? So, Lori couldn't afford to pay it, right? So she didn't want to settle either, but she couldn't afford to fight it. Okay, so Lori's looking at one of two choices. One, liquidating all her assets, draining her savings, mortgaging her house, keep fighting, and probably lose at least something. She has risk. Okay, or worse, shut the businesses down, walk away from it all, and hope that the lawsuit die with it. So, this isn't just a bad quarter for Lori. This is, I could lose like 20 years of my hard work territory. And this is before trial. What happens if Lori takes the case to trial and loses? She's looking at the 1.6 million potential class action judgment. She's looking at having to pay the other side's attorney's fees to the tune of $500,000. And she still has her own attorney bills to the tune of $360,000. That's $2.5 million for a small mom and pop operation with just 20 employees. Now, let me ask you, what would you guys do in this situation, right? You don't want to pay this person anything, but you certainly don't want to have this sort of risk either. So what would you do? Settle or fight? And here's the thing, though. Even if Lori could somehow settle this thing, one thing wouldn't change for her. Her fear that this could repeat. Lori still didn't have legal systems in place to prevent this from happening again. Okay, I told her first 3 or 4 calls, Lori, we need to fix this stuff. Okay, you have too many gaps in your documentation. Okay, let me help you. Has she taken me up on the offer? No, she hasn't. Can I force her to? No, I cannot. But you guys get to watch this masterclass and learn some things so that you can avoid being in Lori's shoes. Okay, so you do what you think you're supposed to do. You pay your employees fairly, you treat them well. You work your 60 to 80 hour work weeks to build your baby. And one employee, just one, can bring your entire life's work crashing down in a heartbeat. It's not because you're a bad person, remember, or a bad employer. So the question is, how do we prevent this from happening? It's really a multi-million-dollar question, right? So here's what most small business owners don't realize. For most of them, there's a fork in the road, right? And most choose the wrong path without even realizing they had a choice. They do the left path. They react. They hope that best intentions protect them. They hire a lawyer only when they need one. And they end up paying hundreds of thousands of dollars, if not millions, but after the damage is done. They lose sleep. They lose money. And they end up spending, years fighting litigation that could have been prevented in the first place. So how about the right path then? The right side. Smart business owners set up their legal protection before they need it. They build legal HR infrastructure up front. That way, when a problem hits, they crush it before it becomes a crisis. Now, they spend a fraction on the front end and save hundreds of thousands, if not millions, on the back end. Because, and you've heard this before, it's not about how much you pay your lawyer, it's about when. And so for those who set up legal HR infrastructure up front, they're the ones who end up paying only $20,000, not zero, okay, but a smaller amount, $20,000, when the lawsuit hits, instead of draining their life savings and paying $360,000. So let me show you what it looks like when you take the right path. Okay, now I get to tell you about Bill. Dream scenario story. Okay, Bill, also successful business person, 20 years in business, owned a couple of bakeries and a food service company. His businesses employed about 80 employees on a regular basis, 250 over a 4-year period. Now, before Bill came to us, he had been sued several times, and he had paid off these, what he called frivolous lawsuits, just to make him disappear so he could go about his business. Excuse me. But when Bill came to us, he was done. He told me, Scott, I'm done forking over my hard-earned money to pay off these frivolous lawsuits, disgruntled employees, and their greedy plaintiffs' attorneys. Scott, I've been doing this a long time. Why is it in the last 5 or 10 years, I feel like every time I go to fire an employee, they're going to be disgruntled and I'm going to get sued? And I told him, Bill, it's been going on way longer than that, sunny state of California. Okay, but here's what you can do to reduce your liability and your risk. I call it HR infrastructure. So we put in place for Bill employee handbook, policies on wage and hour stuff, things that Lori was missing. We had all of Bill's employees sign our arbitration agreement with the class action and a PAGA waiver in it. So then 2 years go by. And guess what? Yep, Bill got slapped with a PAGA class action lawsuit. Total exposure, over 5 million. But here's what Bill did differently. Bill went from 5 million in exposure to a one-on-one solo arbitration with a value of less than $20,000. So instead of spending 4.5 years of his life and $360,000 of attorney's fees, Bill was able to shave years off the process and substantially reduce his attorney's fees and costs. Total savings, about 5 million, less than $20,000 value of the settlement, and hundreds of thousands of dollars of attorney's fees and costs. So here's the thing though, what the emotional shift for Bill, right? Bill went from reactive, stressed, and bleeding red to having us file a petition to compel arbitration where we force the individual to sue Bill in arbitration on a one-on-one basis only, and not as a member of a class action or representative of a class or PAGA action. So that one simple step of having legal HR infrastructure in place allowed Bill to be calm and in control. Not exactly with a smile on his face, but he could go about his day-to-day business, without that pit in his stomach every time he went to fire an employee, because he knew that if any disgruntled employee tried to sue him, they'd hit a wall. And so that's what it looks like, can look like when you take the right path, right? Same industry, same legal risks, same crazy California law, and yet dramatically different result. Okay, so that's the end of the story. Is enough of that, right? So now let's get down to brass tacks and the secret sauce. So how do you do this thing? Legal HR infrastructure. So here's the key part, the 3 very simple steps, all critical though. Step number 1, you need a rock solid, you need rock solid written policies on this wage and hour stuff we've been talking about. You need accurate daily time records and accurate pay stubs. Sounds easy, right? But this is a step that I still see it every day. Most California employers skip like Lori did. And guess what? Quite frankly, it's why they lose, or at least they severely hamper our defense. But it's super easy fix. Just put in place an employee handbook. Pretty much every California employer these days needs one. And among other policies, it's going to contain 4 policies directed towards your wage and hour policies directed to your non-exempt employees. 1, a timekeeping policy that requires them to record all of their actual hours worked. No more, no less. Simple, right? Policy will state working off the clock is strictly prohibited. Second policy, you give them 10 minutes of paid rest period for every 4 hours worked or major fraction thereof, completely off duty. Policy number 3, meal period policy. This one's unpaid, off duty for every 5 hours worked. And then you need an overtime and double time policy that complies with quirky California law. Now, accurate time records. It blows my mind. I continue to see this. People don't have accurate time records. Okay, these days you need an electronic timekeeping system, not manual, not calendar, not schedule like in Lori's case, not text. I've seen it all. The technology is there, an electronic timekeeping system that records time to the second. It's another trend in California law. There's going to be no more rounding. Technology's there. Okay, record time to the second. And then it's going to accurately calculate all hours worked, including overtime and double time hours worked. Next, every pay period, you're going to audit the daily time records for all employees against the pay stubs. And what you're looking for on the time cards or records is 4 things, 4 punches. Number 1, in for the day. 2, out for the meal period. 3, back from the meal period. And 4, out for the day. And those meal periods, you're looking for them to last at least 30 minutes. Not 27, not 29, at least 30 minutes. And they have to start no later than the 5-hour mark. Okay, so by 4 hours and 59 seconds into the shift, we need to see that punch out for the meal period. Okay, once you do all that, you have step one of your battle-tested legal shield in place. Okay, so the next time somebody comes to you and says, hey, I didn't get my rest periods, or I worked off the clock and now you owe me overtime, or I worked through my meal periods and you owe me overtime. Here's what you do. You show them the written handbook policies, you show them their signature on the handbook acknowledgement. I forgot to say, you're going to have everybody sign this, current and future employees, your handbook, custom handbook, right? You give them their accurate daily time records and pay stubs. Because without these things, California law, like I had to tell Lori, pretty much tells you you're toast. You lose pretty much, at least something. Okay, it makes it hard for us to defend. But with these things in place, you shut down those frivolous lawsuits. All right, second step of the legal HR infrastructure. You need a state-of-the-art arbitration agreement with a class action waiver and a PAGA waiver in it. So what some of you may not realize on this masterclass is that California law and federal law allows you to force now all your employees to sign a mandatory binding arbitration agreement where they agree to sue you on a one-on-one basis only, one-on-one, not as a class action, and the PAGA action gets stayed, or put on hold, basically. Until what? Until when? Well, until you arbitrate the individual claims now against that individual employee, if you haven't settled it by now, okay? And then when you win, okay, sorry, my code of ethics prohibits me from guaranteeing any win, unlike the attorney commercials that I saw last week on TV. But, if you follow these steps, okay, I promise you, you'll be in a really good position to win. And when that happens, guess what? Employee gets zero. Case just came out on this issue. Zero. Class allegations have already been dismissed. So that's worth zero. And then now the PAGA action gets dismissed as well. Zeros across the board. They can't drag 250, like in Bill's case, number of employees he had, 250 of their unwilling coworkers into the case or the fray. They can't turn a one-on-one $19,000 wage and hour case into a $250, $5 million wage and hour PAGA case. And that's the monumental shift, right? That you take away the greatest point of leverage, which is numbers, just one, not 85 or 250, okay? And so that's how you go from a $5 million exposure case to something that's worth way less than $20,000, okay? Get out of the case quickly. Okay, third and final step. You see that suit up on your screen with the red tie? You need a knowledgeable and experienced employment and labor law lawyer in your back pocket. So that way, when an issue comes up, right, whether it's a termination, a leave issue, perhaps some of you have entitled employees, or even worse, you feel like you're walking on eggshells in your own business. So here's what you do. You pick up the phone, you call us. We're there for you in real time. We give you real legal advice to nip the problem in the bud and avoid the lawsuit in the first place. And the more you use our preventive day-to-day legal advice, the more confident you become in managing your workforce. You make less mistakes. And that's what keeps you from writing $300,000 settlement checks. Okay, so what does it look like when you put this all together? Okay, you work with us immediately. You'll nip the problems in the bud with our real-time preventive legal advice. Within a couple of weeks, or probably even less, you have your custom employee handbook and your state-of-the-art arbitration agreement in place. We'll audit your at least one round of, one pay period, the daily time records against the stubs. Make sure everything's up to snuff. And at that point, you'll have your battle-tested legal shield in place. Okay? But what makes this different from hiring your average law firm with a $15,000 retainer? Okay, well, most legal advice, including my own 99% of the time, because that's when you all come to me only after there's a problem, most legal advice only treats symptoms. But with this, you build legal immunity. You prevent the problem in the first place. But here's the thing, though. Most stay stuck in the reactive path, right? They assume best intentions will protect them. They think it's not going to happen to me. And then when it does, It's inevitable in the sunny state of California. It's just a matter of time. When it does, then they scramble, they panic, they do whatever it takes to make it go away. And that's what ends up with them writing $300,000 settlement checks. Well, what about our best clients? They make one decision differently. They build their legal HR infrastructure up front. They don't wait for the lawsuit to knock on their door. And that one decision, that one shift in mindset, it's what determines, makes the difference of shutting your doors, shutting the business down, or living to fight another day. And here's what it looks like over time. So that graphic, the orange reddish line going from left to right, those are quarters on the bottom, quarter 1 through 13, and money bottom to top, $0 to $400,000. So time and money, fighting lawsuits escalating over time. That line, that's the reactive business owner. They're constantly putting out fires. They're stressed, right? They're writing checks to their lawyers, okay? But again, after the damage is done. What about the short green path, the short one that ends abruptly? Okay, they're calm, they're protected. They spend a fraction of what the reactive business owner spends because they've dealt with it up front. So one path, the orange reddish one, leads to 6-figure settlements. Trust me. Okay. And years of misery and sleepless nights in the form of litigation. The other path, the right path, ends abruptly, leads to quick resolutions and peace of mind. So which path do you want to take? Time for another quick poll. Okay, so who sees the value of protecting their businesses? It's a rhetorical question, right? Who wouldn't? Okay, so what does this mean for you personally? Well, I'd like to invite you to a free legal strategy call with me. This will be a working session where we take a look at your exposure, map out your vulnerabilities, and build a custom legal plan to eliminate your employee wage and hour lawsuit risk. Now, you'll walk away from our call with total clarity on what's leaving you exposed right now, remember? And again, total clarity what to do about it. Now, you'd have to pay most law firms, not mine, but most law firms, a $7,500 just for this one call. But if you were to spend, say, 30 minutes with me, and we were able to save you from prevent one employee wage and hour lawsuit, that would be worth it. Now, wouldn't it? Okay. Now that's a leading question, right? Okay. So now you're ready to book your free legal strategy call with me. 2 ways to do it. Okay. And I see that question's been asked. And if you don't mind, I'm going to save all questions and we'll answer them all at the end. Get them all answered. Okay. So 2 ways to book. One is to scan the code on the screen or click on the button on the screen. Okay. Book today. And when you do that, you'll have 2 bonuses in the purple boxes available for your immediate download. Bonus number 1 is our top 10 employee lawsuits report and how to avoid them. Knowledge is power. Second, our 10 biggest mistakes businesses make choosing somebody like me, their employment and labor lawyer. Okay, so go ahead, book your call now, scan the code, click on the button, get your free reading. So we're almost done here. There's only 2 kinds of business owners. Okay, savvy business owners who prepare upfront, they're proactive. Okay, then there's sloppy business owners who wait till it's too late. And as you gathered, which one do you want to be? I don't have to ask, right? Okay, well, here's the thing though. My availability is, the space is limited. I'm only going to be available for these calls tomorrow, Thursday, Friday, Saturday, and Sunday. You guys work weekends, right? As hardworking small business owners. And Monday. After that, I'm out for 3 weeks out of the country. So if you're serious about reducing your liability exposure before that lawsuit hits, book your call now and let's get you taken care of. Okay. You'll walk away from our call with total clarity. That I can guarantee. And no pressure though, just a clear path forward. Okay, so click on the button, scan the code. Now I'd like to leave you with one final thought before we wrap up. Now you all have a choice to make today. Either keep doing what you're doing, the left path, okay, hoping that best intentions protect you, waiting for something to go wrong, and then forking over your hard-earned money to pay for to the tune of $360,000 to settle the case or fight it, right? And then still have risk. Or do the other side, the right path, right? Put your legal HR infrastructure in place today. Let me help you. That's what the legal strategy call is all about. So go ahead and book your call, scan the code, click on the button. Okay, and with that, including the this masterclass, I want to thank all of you for your valuable time. It was my privilege to spend this time with you, and I hope at the very least you learned something here. Okay, so like I said, I'm going to stay around to answer all the questions that you have. It doesn't have to be limited to the content of this masterclass. It can be anything employment and labor law related. Think of it as a free consult. You must also take advantage of the time. Okay, thank you very much. And like I said, have a great weekend. I'll stay around for all the questions. Okay, so let me see here. Okay, wow. All right, for new business owners, can you dive deeper into what is considered a good, quote, good, that's correct to put it in quotes, outcome in terms of legal fees per demand letter, legal issue, etc.? It seems that 10 to 30K is considered a quote good outcome, and 100,000 plus means you weren't prepared. That's number one. And then two, what do you do if your current software for billing payroll makes it essentially impossible to do payroll by the minute, seconds? Are there conditions where you can round? Okay, so for the first question, I think that's pretty much kind of accurate, right? These days in California, you get sued, even if you have everything dialed, I'm going to say, right? The number doesn't have to be 10 to 30,000 to settle it. It could be less. It could be that we even get the case dismissed. It happened in one case my firm handled, for nothing. So with this case dismissed without prejudice, and case was over, right? Didn't have to pay anything. So it's probably on the lower end if you have this stuff dialed in a wage and hour case, something like, maybe 5 to 10,000. Okay, if there's some problems, and we're talking about just wage and hour, we're not talking about any other wrongful termination, harassment, or any of that, retaliation type of claims alleged as well. 10 to 30, 30s are on the higher end. I would say 10 to 20-ish, 25. And this obviously really depends on the facts, right? How long has this employee been employed by you? How good is your legal HR infrastructure? Is it there or is it not? All right. 100,000 plus means you weren't prepared. Absolutely. And it's easily 100,000 plus. For clients that have come to us that aren't prepared, $300,000, $800,000. Okay, depending on the size of your workforce. So these are sizable claims, and again, could be prevented in the first place. You're paying attention today. Like I said, go off and implement this stuff, but again, with advice of a knowledgeable and experienced employment and labor law lawyer. Don't just do this on your own. Okay, so what happens if your current software doesn't cut the mustard? You change it. This is a must these days. It's not a maybe. Okay, there is no more rounding. There's a case before the California Supreme Court that's going to decide the rounding issue. And my prediction is the California Supreme Court will say, no rounding. You have to pay, as impractical as that might sound, to the second. And actually, the technology is there right now. All of these electronic timekeeping systems, you can have biometric, facial recognition, thumbprint, all of it is recording time to the second. And so you get away from this rounding issue, and then you have accurate daily time records. Okay, which by the way, you should have all of your employees attest to every pay period that these are accurate. I swear under penalty of perjury that this is my actual hours worked, no more, no less. I got my rest periods, I got my meal periods. Okay, that's a little bit more than what question 2 involved, but there you go. Okay, so I think I'm trying to see. I think there's no other question. Yeah, no other questions, it looks like. So are there really no other questions? Happy to, like I said, free consultation on employment and labor law issues. So whatever you have top of the mind, you can also ask it. So I see that Justin's asked a question. Will the recording for this webinar be available? Absolutely. I do believe it gets sent to you with a follow-up email. Okay, so you can watch it again. Yes, indeed. And by the way, if for whatever reason that doesn't happen, you can email me and then I'll make sure you get it. So my email is scott@visionlaw.com, SCOTT@VISIONLAW.com. I'll make sure you get the recording. Okay, I think maybe another question got asked. No, looks like no worries, Justin. You get the recording, you'll be able to see the whole thing. All right, any other questions? Like I said, I'll stay on as long as there are questions. Most people have dropped off at this point. There's 5 of you left on the call. Anybody has questions? Okay, looks like there no other questions. Again, thank you for spending your valuable time with me. Greatly appreciated. That concludes. Oh, new question. Hang on. Oh, just a thank you. You're very welcome. That concludes today's webinar. Have a great day.